Read the Latin, Charla.
Okay. Known as the legibus et consuetenerbirus Anglisi. Yeah, which is the earliest book of authority in the common law.
There is a text called the Legis Henry. I
Say
swear I
the
can pronounce
fucking Latin, Samuel. And if you want to watch that miniseries, you can always like and subscribe so we can start a Patreon rather than me having to start an OnlyFans to make my second source of income.
Now that is going in the front of the video.
Hello, and welcome back to Uncodified. In this episode, we're going to talk about the creation and the importance of common law and the judiciary throughout the medieval era.
While there is a treasure trove of Anglo-Saxon and early Norman laws that might delight history nerds such as myself, these are not really useful for understanding of our system of common law, so we won't be telling you. Unless you like and subscribe, then we might think about it. You've changed these lines, Charla. You've changed these lines.
Yeah, I did.
The origins of our current system of law and the ancestors of our court can be found in the reign of Henry II, who reigned from 1154 to 1189. The 19th century titans of common law scholarship, Maitland and Pollock, describe the reign of Henry II as of supreme importance to the history of our common law, not because of any great changes in the law, but because of his innovations in enforcement.
Before and during the reign of Henry II, the judiciary was founded in the Curia Regis, literally the King's Court. The court was chaired by the monarch, or by the Justiciar, which is the monarch's deputy, alongside other judges. Within this court, there was a body known as the Exchequer, which managed the financial aspects of government, such as taxation and expenditure, including the military. The people who sat at the Exchequer in this period were members of the king's household: the Justiciar, the Chancellor, the two Chamberlains, the Marshal, and the Treasurer, which overlaps with the judges of the Curia Regis. At this time, all the judicial, legislative, and executive powers flowed to the king as an individual. There were not yet any separate institutions that wielded significant governmental authority other than the church.
So, in 1178, when the Exchequer separated from the Curia Regis, it became the first independent government department in Europe. By the end of the century, the Chancellor had become too important, and the office of the Justiciar had fallen out of place. So, the Chancellor's deputy, known as the Chancellor of the Exchequer, in practice oversaw the department. The Exchequer continued to be a strange crossover between the judicial court and the instrument for raising taxes for centuries.
It often heard cases regarding taxation. This later split with the fiscal work. By Edward I's reign, between 1272 and 1307, collection of revenue was under the control of the Lord Treasurer, assisted by the Chancellor of the Exchequer, while a chief baron and 3 or 4 other barons heard and ruled on the court cases. However, Chancellors of the Exchequer continued in their judicial role for an incredibly long time. Until 1875, in fact, the Chancellor was still entitled to sit as a judge alongside the barons. This is why, in the Separation of Powers essay, we hesitated to agree with Madison that at least until recently that the doctrine applied to the UK. When the government minister responsible for collecting taxes also has the right to judge over cases which would oversee his administration, the chances for the abuse of power is immense.
Okay, so a good starting point to start our exploration of common law are the constitutions of Clarendon in 1164 and the assizes of Clarendon and Northampton in 1166 and 1176 respectively, as the beginnings of the centralisation of justice. The Constitution established where the jurisdiction of the king ended and that of the church began in a clear delineation. This is not a separation of church and state, but shows where jurisdiction of the ecclesiastical courts and those of the kings lie within England. As previously, many people fell within both categories of law and might be tried twice for the same crime, double jeopardy. These reforms include a recognition of a jury in trials made up of 12 men. Stubbs describes Article 9 as the earliest mention of something resembling statutes.
The Assize of Clarendon gave sheriffs the right to investigate crimes on the lands of the lords, which previously might have been considered their own jurisdiction, which has an effect of centralising justice under the King's Court.
A further outcome of the Assize of Clarendon is Henry II's mobilisation of itinerant judges. This is where judges would be sent around the country, separate from the king, to hear cases in local courts and shires. This was developed further in Northampton, where England was divided into 6 circuits, known as eyres, to be travelled by a number of judges to establish the king's law as a supreme authority. The circuit, especially in civil law, began a decades, even centuries-long process of merging local custom into a cohesive common law.
As well as being a meeting between the king and his senior advisers, which redefined the boundaries of law, assizes were a form of early court where 12 men representing 100 present an accusation of a crime, at which point the accused would go on to an ordeal. This is similar to the function of a grand jury in the US, where a body of people are required to agree that there is enough evidence to prosecute a case. Additionally, at the assizes, there is another method of bringing a charge, the appeal, which is brought individually by the wronged party, a relative of a murder victim, for example. This remained in practice until 1819.
Okay. So another Henry II form, which is widely commented on, is the introduction of certain writs. So a writ, generally speaking, is an order issued by a court in the name of a sovereign authority requiring the performance of a specific act, which is the most boring thing I'll say today, hopefully. At this time, it would be more than likely that it would be from the Curia Regis issued by the king. So the writs of Pone and Wright moved land law from the jurisdiction of signorial courts, which means belonging to a feudal lord, to the courts of the king. Now, the writs of Pone gave every free man, not serfs, the right to move a case to either the county court, which was known as Tolt, or the common pleas. The writ of Wright allowed the tenant to choose trial by jury of 12 knights rather than trial by battle,
which would be painful. And trial by battle is the actual term used historically. Trial by combat from Game of Thrones, you nerds.
We are the nerds. I am the king of the nerds. Don't insult my people. All right, moving on. So this is the earliest recognition of a trial by a petty jury, i.e. a jury we'd recognise today. Again, what this did was have a centralising effect, taking justice out of the hand of barons and into the hands of central government.
If you want to know why he paused there, it's because I wrote in the script, smelly barons. Our knowledge of the early medieval period, well, detailed, is not complete. As such, the origin of the medieval common law courts is disputed in the academic literature. This is a common theme. We know that a court was created in 1178 from a contemporary source, which I will quote to the best of my ability. When he learned that the land and the men of the land were burdened by so great a number of justices, for there were 18, chose with the council of the wise of his kingdom 5 only, 2 clerks, 3 laymen, all of his private family household, and decreed that these 5 should hear all complaints of the kingdom and should do right, and should not depart from the king's court, but should remain there to hear the complaints of men, with this understanding that, if there should come up among them any question which could not be brought to a conclusion by them, it should be presented to a royal hearing and be determined by the king and the wiser men of the kingdom.
Whether this was the Court of Common Pleas, the King's Bench, or another court, which later split into two to form both courts, was heavily debated in the late 19th and early 20th centuries by Stubbs, Maitland, Pikes, Adams, others. Honestly, this goes on forever. This is like 80 years of pure academic squabbling. So Pluckner in 1956 writes that this court might not have been either of those courts, but an experimental court that went nowhere, but it's fairly likely, and most people do tend to agree, that it was likely the Court of the Common Pleas.
Adams believes that changes that occurred under Henry II, including the new and more powerful systems of court, writs, jury trial, and the common law, not only created the beginnings of our judicial system, but also the basis of our constitution.
So now it's time for some deja vu. We're going to look at the Magna Carta again and its impact on the law and judiciary, and we're going to look at it from that perspective rather than that of Parliament. Go ahead, Charlotte.
In terms of constitutional matters, in Chapter 18 of the Magna Carta, the king was required to make the court accessible by holding assizes 4 times a year in all counties, which makes him a very busy man. In Chapter 17, that the Court of Common Pleas should be held in a fixed place, and Chapter 36 of the Magna Carta, that a trial by jury should be allowed instead of a trial by ordeal. The 1215 Charter also established the principle of the rule of law in Chapter 39, which I will also quote. No free men shall be taken or imprisoned or dispossessed or outlawed or exiled or in any way ruined, nor will we, the king, go or send against him except by the lawful judgments of his peers or by the law of the land.
So while this applied to free men, it didn't apply to serfs.
Sorry, guys.
There was still a legal hierarchy. Chapter 60 of the Magna Carta also took an axe to the feudal system by requiring that lords grant to their subordinates the same right that the king was granted to them. In 1215, because the Magna Carta insists on trial by jury, trial by ordeal was effectively abolished, after which the law evolved that if a person was accused by grand jurors, they could either be investigated by their neighbours or be imprisoned. There is some ambiguity about how trial by jury was viewed at this time. Bracton and some judges of the King's Bench believed that even without volunteering to be tried by neighbours, they could still be tried and sentenced by them. However, being tried by a jury without choosing to submit to it was considered to be incredibly unjust, as the idea was brand new, and trial by ordeal or by battle was seen as God's judgment and therefore more reliable than 12 men who were simultaneously witnesses and jurors.
So maybe be a little partial in those decisions. But by the end of Edward I's reign, trial by jury had become the norm in civil cases, with very occasional use of trial by battle. In criminal cases, an accused can choose trial by jury. Their consent is required, but if it is withheld in practice, the accused will be pressed or starved, both of those being slightly less enjoyable than maybe jury. Because jurors in this time are also witnesses, the defendant on the trial after the verdict can bring a case against the jurors for perjury, where the 12 juries would face another jury of 24. And you may think that this could, double every time, but
It does.
they had sense and it doesn't. This shows just how messy early common law was, where the jury was the authority that would indict, provide evidence, and judge a case, and could be held responsible for a wrongful conviction.
So we're going to look at books of authority. So books of authority are exceptions to the rule that textbooks cannot be used in court as a source of law. These commentaries on law can be used in court cases with the same influence of case law or statute as they are seen as an original source of common law. They are also excellent historical source of what the law was and often demonstrates the state of the Constitution, the courts, and legal theory at any given time.
The reason we know so much about the changes made by Henry II is a manuscript known as Glanville.
Read the Latin, Charlotte.
Okay. Known as de legibus et consueterebus. Yeah, which is the earliest book of authority in the common law. Like much else in early medieval history, the authorship has been debated, but it is traditionally attributed to Ranulph de Glanville, the distant cousin to Gandalf the Grey, who was Justiciar between 1180 and 1189. He is not regularly cited in courts, to say the least. His main use to us is understanding very early developments in common law.
So in the 1100s through the 1200s, English law was on a transformation process.
Like a caterpillar in a cocoon.
So, moving on. Several decades before Glanville, written between 1113 and 1118, there is a text called the Leges Henrici Primi, Laws of Henry I, which completely predates the common law. It shows a chaotic mix of legal systems, in addition to the varied laws and customs of Anglo-Saxon kingdoms. And the Dane law, there is also canon law, which is church law, Frankish laws, and civil/Roman law. In contrast, the law that Glanville reports at the end of Henry II's reign is homogeneous and clear. It is not yet the common law. That takes centuries to truly develop, but it's recognisable and coherent. Glanville was still useful as a legal text for 100 years after it was written, even after Bracton's more comprehensive treatise was released.
Maitland and Pollock, not to be mistaken with Jackson Pollock, speculated that Glanville had read Justinian's Institutes and other Roman and canon law, and this might have determined his idea of what a law book ought to be. Glanville distinguished between criminal and civil cases in a way which reflected Roman law, but doesn't rely on it elsewhere in the text. Land law, in particular in this period, was discussed in a way that was different from Roman law. And for you land law enjoyers out there, and I know some of you are watching, this may be part of the reason why UK land law is so brain-numbingly bamboozling.
Yeah, so now we're going to look at a text which has been called the Flower of Jurisprudence, Bracton's De Legibus et Constitutionibus Anglia, or On the Laws and Customs of England. So, like Glanville, what we know about Bracton, both the text and the person, is not so certain. For instance, Maitland and Pollock suggest that Bracton had been written between 1250 and 1258, whereas later scholarship by Fawn contests this, highlighting intersections which suggest that parts of Bracton were written before the provisions of Merton in 1236. Both Maitland and Fawn thought that the treaty was an accurate reflection of the 13th century law, but Barton questioned aspects that seemed to be Bracton's opinion on law that was no longer in place. Bracton was an itinerant judge and a judge in the Coram Regia, which means in the King's presence, in the court of Henry III, who is believed to have been born in Devon and been a judge at the assizes for 20 years, sitting at Exeter, Torrington, Barnstaple, and other places. He was also a priest and Chancellor of the Exeter Cathedral, where he is buried.
Bracton was heavily influenced by Roman law, primarily because the common law did not yet exist. Quote, before 1190, in the time of Glanville, English students would have to go to Paris, Bologna, or other continental universities to receive instruction in Roman or canon law. By the 1230s, this was taught at Oxford, but it was still Roman law based on Justinian's Institutes, not English law or custom. The extent to which Bracton was following Roman law or as representing English law is another thing debated by academics. And there was a number of Roman and canon law writers which he refers to. When he is writing about English law, he uses Roman terminology. He refers to aspects of law like contract, fraud, and negligence, which hadn't been developed yet in English law. Something to keep in mind is that the books of authority do not always accurately reflect the real practice of the courts. There are yearbooks which disprove points that are agreed on by Glanville, Bracton, Fletter, and Britton. Bracton provides us with a valuable insights in the English common law of the late 1220s and 1230s, but it's not absolute. The common law was constantly developing, and the nature and content of English legal custom during the second half of the reign of Henry III needs to be established from the evidence of surviving plea rolls.
So Bracton, unlike Glanville, still has a huge influence on the common law. For instance, in 2022 case, Dobbs v. Jackson, US Supreme Court Justice Alito quoted, and in my view misrepresented, Bracton's justification as to why Roe v. Wade and Planned Parenthood versus Casey should be overturned. So the following bit is an extract from my master's dissertation.
Because why do the word twice when you got distinction the first time? Am I right, Samuel?
Indeed, thank you very much. Okay, so for example, according to Bracton, if a person beats a woman or poisons her, and that act causes the death of an animated fetus, quickened basically between like 16 and 18 weeks, that's limited in early common law, then it is murder. Alito uses this to argue that the act that we consider abortion today was historically considered as murder. However, this is a false equivalent between a woman being a victim of assault and or attempted murder, resulting in miscarriage, and a woman choosing to end her pregnancy for a myriad of medical or personal reasons. As a result, a 13th century text played a part in allowing many US states to ban abortion to severe degrees, with serious consequences. Shortly after Dobbs v. Jackson, a 10-year-old rape victim was forced to travel across state lines to access medical care. Additionally, women in Texas with unviable pregnancies are denied the ability for medical care. There are no exceptions for rape in many cases, in many states, or age, or even in very rare cases mother's health. So this is a real issue that the misinterpretation of common law has led to. And it demonstrates how seemingly ancient parts of the common law can still influence lives across the English-speaking world today.
Bracton is a good source for determining not only where the law stood on issues of manslaughter and inheritance in the 1200s, but also the constitutional relation of the king to the law and the courts. Bracton speaks carefully on this issue, since to declare outright that the king is subject to the law could invite trouble of the off with your head variety. He first states that the king has no equal within the realm because he will be subject of those subjected to him. But then almost immediately, Bracton, the rebel that he is, seeks to restrain the king by law. While the king is not responsible to a man, he is to God and the law. He argues that the king should follow the example of Jesus, as there were many options open to Jesus to redeem humanity, but he chose to use justice rather than force, and that he willed himself to be under the law that he might redeem those who live under it.
Bracton states that there should be no person higher than the king in doing justice, but he should be the last person to receive it if he was the plaintiff, as there is no method to enforce the king following the law, but then couches this statement on the limits of the king by saying that only God can hold him to account and no one must act contrary to the king. Basically, the king shouldn't use the law to get his own way, but if he does, no one can say anything.
Which is a bit of a tricky situation. But again, much later, Bracton says that the king should let the law control his power, or otherwise he will be a tyrant, and that as the law is the source of his power, that the laws of mankind bind the lawgiver. And I quote, "Nothing is more fitting for a sovereign than to live by the law, and he ought properly to yield to the law that the law has been bestowed upon him, for the law makes him king."
So, whilst Bracton might be quite hesitant to state this quite radical idea of the king's subservience to the law, Glanville's position on the power of medieval monarchy lacks any of this nuance. Glanville says the king has no equal, much less a superior. So, in half a century, some really significant changes have happened in how the monarch is viewed in relation to the law, from Henry II to his grandson Henry III.
Bracton highlights how unusual it is that England does not have a codified system of law, and how unwritten law and customs are the norm. I quote, "Their law derives from nothing written, but from what usage has approved. Nevertheless, it will not be absurd to call English laws lieges, though they are unwritten, since whatever has been rightly decided and approved with the council and consent of the magnates and the general agreement of the res publica, the authority of the king or prince having first been added thereto, has the force of law." At first glance, this appears to reference something resembling a statute, which might be a bit anachronistic. Additionally, the words used by Bracton to describe the customs should be used to describe Parliament if it were not too early, since they have been improved by consent of those who use them and confirmed by the oath of kings. They cannot be changed without the common consent of those whose counsel and consent they will promulgate. At the point Bracton writes, it is clear that the law is still decentralized and local customs in counties and cities still need to be learned in order for justice to be properly done.
So we actually have Bracton's notebook, which was discovered in 1887, which provides an excellent view on case law at this very early stage of common law. If we were to really delve into it, it could be a mini-series in itself, but if you're interested, it is available on Google Books for free. Moving on, away from Bracton, we're going to look at the Court of the Common Pleas and the King's Bench. So by the end of the reign of Henry III, which is 1216 to 1272, there are three main courts that have evolved from the Curia Regis during the medieval era. The Court of the Common Pleas, the King's Bench, and the Court of the Exchequer. Each will have their own hierarchy. We've already covered the Exchequer. And so Charlie wants me to tell you, we will not cover, again, so you better be paying attention. This is Charlie's line, not mine, just to be clear.
Exactly, you better be paying attention. Seriously. Watch the episode properly. As we have already established, the Court of Common Pleas was probably established in 1178, which you would know if you were listening earlier, and separated from the King's Court as was required by the Magna Carta. But to start with, these courts are made up of the same judges, and due to Henry III being 9 when he ascended the throne, which is a bit young to make sense of anything in the world, because I think I only figured out what a car was at around 12 and understood, ratio dynamics and his ability to hold his own court was a legal fiction. And so the courts in practice remained linked until the re-establishment of the Curia Regis in 1224.
So from 1237, we have cases showing that there was a legal distinction between the jurisdiction of the Curum Rege, which is the court held in the King's presence, and the Common Pleas. And by 1272, there is a separate Chief Justice with separate records. In the 14th century, judges stopped being chosen from clerks of the King and started to be chosen from barristers who had practiced law in courts known as sergeants of law. The jurisdiction of Court of Common Pleas was concerned with civil law and private disputes between individuals, and with the exception of trespass, had total jurisdiction in civil law. So Holdsworth quotes Coke's writing in the 1600s as saying, "This court is the lock and key of the common law in common pleas, for herein are real actions whereupon fines and recoveries, the common assurance of the realm do pass, and all other action by original writs to be determined, and also of all common pleas mixed and personal," and I killed that. Move ahead, Charla.
Yeah, well done. I mean, congratulations. That was actually really good. I think you should like and subscribe. During the reign of Edward II, the extent of his jurisdiction and its reputation were so popular that the king split it in two from the yearbooks, which are early forms of law reports. We can see that it had the most cases before it, although this had started to change by the 1500s. The King's Bench was a court held in the presence of the king. Even up to 1875, it was still technically held before the monarch. In medieval times, it was literally justice administered by the king, as was done by both John and Henry III, who really wanted to be there in person. But it was, but it was not only roughly a century after the establishment of the Common Pleas as a distinct court that the King's Bench was sufficiently separated from the Crown. The books of authority, Bracton and Fletter, both hint at some separation between the King's Bench and the Coram Regi during the reign of Edward I. In reality, the split between the two occurred gradually over the 1300s and the 1400s. The king is considered not to have been able to pronounce the judgments himself. In the 13 and 1400s, common law judges subscribed to the idea of a supremacy of law.
Whilst criminal cases had to begin in the county a crime was committed, the King's Bench justices could claim jurisdiction from local court when it sat in the country. The King's Bench also had the power over all royal officials, such as sheriffs, and would entertain complaints against them, and compelled them to carry out their duties. Furthermore, the court had jurisdiction in civil law, which in the modern vernacular was overpowered, as any case in which a defendant could be charged with a breach of the King's peace, which was very broadly defined, the King's Bench ended up posting those cases from the Court of Common Pleas.
Which makes sense when you consider that they got paid on a case-by-case basis. While the Common Pleas had an effective monopoly on civil litigation, apart from trespass for centuries, the King's Bench by the 1400s was becoming a final court of appeal from other courts. Both of these courts were subject to interference by both the King's Council and Parliament. For instance, in the Staunton's case in 1346, the King's Bench gave up jurisdiction to the council to be tried in front of all of the justices.
This case was a family dispute that at first was decided in Parliament, only for the Chief Justice of the Common Pleas to declare Parliament's ruling to be wrong, at which point the Chief Justice of the King's Bench and his predecessor were consulted and gave different opinions, at which point Parliament ordered the bench to judge the case before the end of the session, or come to Parliament give the ruling there, at which point the entirety of the medieval government proceeded to rule on the case, including the Chancellor of the Exchequer, Justice from the Common Pleas, and the King's Bench and other members of the Council in the session of Parliament, and that's the end of it.
Well, at which point we must turn to the High Court of Parliament. In the reigns of Edward I and II, Parliament is a complete fusion of powers, and while this was the case in some form until Tony Blair, medieval Parliament is a Gordian knot of overlapping powers. Fletter, a book of authority written in 1290 according to Stales, states that the king has his courts in his council in his parliaments. The Crown, Parliament, and courts of law are all descended from the Curia Regis, which has the side effect that for centuries Parliament functioned as a court.
So judges in the King's Council through the reign of Edward I to Henry VII assisted the king in drafting legislation before it was put to the two houses for approval. As we covered in the last episode, Edward I passed a lot of substantial legislation, but the majority of business in Parliament was addressing petitions, as we have a contemporary source from 1311 that states, "Many folk are delayed in the King's Court because defendants allege that the plaintiffs ought not to be answered in the absence of the King, and many are also wronged by the ministers of the King, which wrongs They cannot get redressed without the Common Parliament. We ordain the King hold a Parliament once a year or twice if need be, and at inconvenient place. And in the same Parliament shall pleas that have been delayed and pleas about which judges differ be recorded and determined, and in the same way the bills which shall have been handed into Parliament. In this way, the Parliament of the 1300s is a final court of appeal.
Over the 13 and 1400s, a significant part of the High Court of Parliament came to be found in the House of Lords, which developed significant judicial powers in its own right. The Lords had a long-standing right to try their own members. This was codified in the Magna Carta, which predates the forming of the House by 136 years, which is quite a long time. The right to trial by peers was expanded under Henry III to include treason. Bracton's reasoning for this is otherwise the king would be his own prosecutor and judge, and that all other judges were representatives of the king. They would be equally unsuited, and so judgment was given to the peers. This essentially set up a separate tier of law where earls and barons could only be judged by other earls or barons. Other substantial power the Lords had was to try impeachments of government officials, which we could do more of in this day and age. We will look into this as much more detail on the next episode on the 14th century Parliament, as that is where the practice originates from and develops.
The House of Lords was also a court with jurisdiction. In 1341, Edward III passed a statute which built on the role of the High Court of Parliament as we saw it in 1311. This legislation essentially delegated 5 lords with the advice of various members of the King's Council, including judges, to make rulings on petitions in between sessions of Parliament. As the common law courts developed, the Lords' jurisdiction over civil law shrunk, especially as by 1381 the King's Council would begin to separate from Parliament, meaning that the link between the Lords as a court and the King stretched. In terms of criminal jurisdiction, it may have existed outside of the peers, but another statute of 1352, which forbade arresting anyone without an indictment, meant that the Lords could not arrest people on the basis of a petition. This doesn't mean that the Lords couldn't try cases of criminal type, but it would have to originate in another court and then move there.
By the end of Edward III's reign, we have a hierarchy of courts where appeals from the Court of Common Pleas went up to the King's Bench, and errors in the King's Bench can be brought before Parliament. In practice, the Lords at this time consider a final decision with equal authority to the Curia Regis. This is perhaps the first element of a sovereign Parliament. Still reliant entirely on the King's authority, but by the time we get to the 1400s, the ultimate judicial authority is not entirely found in the King, but in Parliament, of which the King is the foremost part.
So in this episode, we have explored the origins of English law and common law courts in medieval era. We've also explored the relation between the King and the law, as well as the emergence of the High Court of Parliament. If you fell asleep in any of these sections, like we almost did, because it's like 11 o'clock at night when we're recording this, you may ask us any questions you like in the comments, and we've also said that if you are interested in covering any aspect of this in more depth in future, please let us know. Do we have anything else to say, Charlie?
No, I believe we've wrapped it up, and we hope we've all learned and also been entertained.
Yes, by our
we'll see you.
and we hope you have a wonderful day, folks. Goodbye.
Yeah, and see you in the next episode.